Hello, everyone, and welcome to today's panel on stare decisis and the Roberts Court, which is one of a series of panels being offered this fall on the role of the judiciary in a constitutional democracy. Today's topic involving stare decisis is an exceptionally important one. Since the earliest years of constitutional history, all of the justices of the Supreme Court have purported to embrace some version of the doctrine of stare decisis, which roughly is the idea that the Supreme Court should adhere to precedent. But the doctrine of stare decisis has always been, and in some ways has to be, a flexible one, because everybody agrees that the Supreme Court should correct some past mistakes, such as what nearly everybody takes to be the past mistake in Plessy against Ferguson or Lochner against New York. In addition, the doctrine of stare decisis has a quasi-paradoxical aspect. This is because the doctrine of stare decisis only matters in a situation in which a justice believes that a prior case was wrongly decided. So suppose the question before the Supreme Court were whether the court should overrule Marbury against Madison or Brown against Board of Education. Any justice who thought that Marbury was correctly decided or that Brown against Board of Education was correctly decided could decide the case directly on the basis that it reflected the proper interpretation of the Constitution. So if the doctrine of stare decisis matters, it would matter only because a justice who thought that Marbury was wrongly decided or that Brown was wrongly decided should now vote to uphold it because of the courts having made a mistaken interpretation in the past. But then why should a justice vote contrary to what he or she thinks the Constitution requires? That is the fundamental philosophical and constitutional question about stare decisis. Some people say that the doctrine of stare decisis is fundamental to the rule of law, which requires stability. Other people say that stare decisis is especially important to keep the Supreme Court from blowing too much with the political winds, which of course is what some people think the Roberts Court is doing right now. In fact, some commentators think that most or all of the justices of the Roberts Court do not attach any significant weight to precedent at all, as illustrated by the Supreme Court's recent controversial decision in Dobbs against Jackson Women's Health Organization, in which the court overruled Roe against Wade. Following Dobbs, there are looming questions about other precedents that the Supreme Court may or may not be poised to overrule, including iconic decisions upholding rights to same-sex sexual intimacy, a right to gay marriage, and the right to contraception. And among the uncertainties as we look ahead to what may be coming, a number of commentators and indeed some justices of the Supreme Court have argued that adherence to precedent is crucial to the Supreme Court's legitimacy. Legitimacy is an important and complicated concept in its own right, but for present purposes, I take the central concern to be whether the public will perceive the Supreme Court as an institution that is above and outside of partisan politics. If the perception broadly took hold that the Supreme Court is just another partisan institution, I'm not sure what the consequences would be, but there are many people right now who are worried about those consequences, and that may be one of the things that our panelists will want to talk about today. For today's panel on stare decisis, we're privileged to have a most distinguished and diverse panel. Michael Dreeben is currently a partner at O'Melveny and Myers. Before that, he worked in the office of the Solicitor General for over 30 years and has argued over 100 cases before the Supreme Court. James Gibson is a professor of political science at Washington University in St. Louis. He is among the nation's leading experts in law and politics and has written extensively about judicial legitimacy. Tara Grove is the Vincent and Elkins Professor of Law at the University of Texas Law School. In addition to having written about judicial legitimacy, she's one of the country's foremost scholars of the constitutional separation of powers, including the role of the Supreme Court under the separation of powers. Darren Hutchinson holds the John Lewis Chair for Civil Rights and Social Justice at Emory University School of Law. His fields of expertise include civil rights, gay rights, LGBT issues, sexual orientation, and transgender rights. Kimberly Robinson is Supreme Court reporter for Bloomberg Law. She's also a graduate of Columbia Law School, and before making the switch to journalism, spent 5 years as a practicing lawyer at Morrison and Foerster. Given this extraordinary panel, I hope to keep my role quite limited and to make today's event as much as possible a conversation among the panelists. Our tentative plan is as follows. To kick off discussion, I will ask each of our panelists a relatively open-ended question to which they will respond in a talk of roughly 5 minutes. I'll then ask the panelists if they want to respond to each other, and I may pose a few further questions to provoke conversation, but I promise you that by 1:20, I will have wrapped up any part of my function moderating discussion among the panelists, and we'll go to the audience for questions. If you want to ask a question at any time, you could start typing your questions into the chat function, and we'll be eager to get them. And so with that, without further ado, I will go to the panelists in alphabetical order. And so let me start with you, please, Michael Dreeben. In recent years, a number of commentators have suggested that the Roberts Court doesn't really care very much about stare decisis, is illustrated by last term's decision in the Dobbs case, which overruled Roe against Wade. Based on your extensive experience litigating before the court, how much influence do you think that stare decisis has on the way the justices think about how to decide cases? And do you think that that influence is lesser in the Roberts Court than it has been in previous courts?
Thank you very much, Dick, for your introduction, for the question, and for your setup of the topic of stare decisis, which covered a lot of the essential questions. The question whether the Roberts Court cares about stare decisis, whether individual justices care about it, whether it is different from the past, is both a little bit impressionistic and a little bit empirical. It wasn't so long ago that in 2000, in Dickerson versus United States, the Supreme Court reaffirmed Miranda versus Arizona in an opinion written by Chief Justice Rehnquist that surprised many observers because he was a well-known opponent of Miranda, thought it was wrongly decided, and had written many cases that undercut its fundamental rationale. And yet he wrote an opinion sustaining it against stare decisis, invalidating a federal statute, and saying memorably that Miranda warnings have become routine to the point where they are embedded in our national culture. So that looked like, well, stare decisis is playing a significant role, at least in one case. And then, of course, before that, Planned Parenthood versus Casey in 1992 was a epic reaffirmation, in part, of stare decisis while modifying an earlier precedent. But everything seems different now, today. Partially, this is the phenomenon of being in the present and having that be more vivid to us than any other period of the past. A giant fell last term in Dobbs. This was pretty much the Mount Everest of issues about stare decisis. And so I think it feels to all of us that it just doesn't matter. And we're on the cusp of another term where the court has before it the Harvard and UNC race conscious admissions plans, which involve a frontal assault on Grutter, and before that going back to Bakke. And many observers think that the court is poised to overrule those as well. So it does make sense to ask whether we're in a new era in which landmark precedent after precedent will yield to the same 6-3 majority that gave us Dobbs and that people expect may give us an overruling of Grutter. So looking to research, the Congressional Research Service issued a report in 2018 in which it examined the history of overruling precedent. It found 5 decisions in which the Supreme Court overruled precedent in the 19th century. In the 20th century, it found 116. And in the 21st century, it recorded 20 through 2018, and we've had about 5 more since then. So to the extent that we are looking at empiricism, the court has averaged about 3 overrulings a term since 1946. And the precedent-shattering decisions that we have had recently do not really form an exception to the pattern of the court announcing landmark decisions in cases that overruled others. In addition to the 3 that got featured in the stare decisis discussions in Dobbs, Brown, of course, the most famous of decisions overruling precedent, West Coast Hotel versus Parrish, which overruled the Lochner line, and the Barnett case, which overruled Gobaitis, a 3-year prior decision about flag salutes. These are some of the landmark cases that overruled precedents. Gideon versus Wainwright, establishing a right to counsel in felony cases. Miranda itself, which overruled a case called Crooker that denied that there was a warnings requirement. Katz versus United States, creating a new test for the expectations of privacy protected by the Fourth Amendment. Lest anyone think that overruling a precedent just runs way, even in the modern era, the Supreme Court decided Crawford versus Washington, which greatly expanded the scope of the Confrontation Clause, Ring versus Arizona, which provided jury trial rights in aggravating factors in death penalty cases, and most recently Ramos versus Louisiana, which overruled Apodaca versus Oregon to find a unanimous right to jury verdicts. And of course, we have Lawrence versus Texas overruling Bowers and Obergefell creating a right to same-sex marriage. So one can ask, listening to that list, and there are many more, well, what is the fuss about today about stare decisis? Political science observers and authors who have been following this area, including Professor Frederick Schauer, has written for years that stare decisis really does not matter very much in the Supreme Court. If the court thinks that a precedent is wrong, whether it calls it egregiously wrong or simply wrong, it is the high likelihood that justices are going to find a way to vote to overrule it. There were some notable exceptions that we've talked about, but those exceptions almost proved the rule. So probably to sum up on this, things look different now because there is a majority that is pushing things ideologically in one direction. It's a super majority, and it's going after landmark precedents, and there may be more on the chopping block as well. But it is not necessarily so clear that in the sweep of history, this court's approach to stare decisis is much different than in the past, which is observed largely in the breach.
So thank you very much. And so now let me turn to Jim Gibson. You have written more than anybody else that I know, and more influentially, about judicial legitimacy. how, from your perspective, does the Supreme Court's pattern of adhering or not adhering to its well-known precedents affect the way the public perceives the court, and whether the public perceives the court as a legitimate institution? And is institutional legitimacy in that sense something that the current justices of the Supreme Court have special reason to be worried about right now?
Thank you, Dick. I appreciate being included on this panel today. I think it's an important panel, and I'm happy to be here. So I've defined my role on this panel as speaking for the American people when it comes to the question of how the court is perceived and evaluated. Now, I suspect that there are a lot of folks in the audience who would regard this as a fool's errand. But I should remind you that legitimacy theory has become one of the most powerful theories in all of the social sciences today, with so many different studies in so many different areas, from central banks to the Supreme Court, relying on the theory. And the reason why is that legitimacy is an invaluable source of political capital for an institution. In fact, some argue that nothing is more valuable. Now, I suspect that most of y'all recognize this as sociological legitimacy. It is the legitimacy accorded the court by its constituents, and we know about it through conducting public opinion surveys. It's quite different from normative legitimacy, and we can thank Dick and others for making this distinction crystal clear. I've spent almost my entire academic career listening to the American people to learn something about sociological legitimacy. I confess at the beginning I know little about normative legitimacy, but I know the panelists will take care of that issue without any problems today. So the issue as assigned, and as Vic articulated just a minute ago, is to determine whether deviations from stare decisis affect the perceived legitimacy of the court. Now, it turns out that social scientists don't know a ton about how decision-making processes influence perceptions of legitimacy. We do not know a ton, but we do know a few things. And the first thing we know is that we're all legal realists now. Now, that probably pertains to everybody in the audience, but it also pertains to the American people. The American people do not believe in mechanical jurisprudence. They do not accept that as an accurate empirical description of how judges make decisions. Instead, they understand that values and ideologies make a difference. Now, I'm not saying that the American people have a complicated and sophisticated understanding of stare decisis. I'm not saying that. But I am saying they know that liberal judges make liberal decisions, and conservative judges make conservative decisions. They subscribe to legal realism. Furthermore, and by far the most important conclusion from this research, is that that understanding does not undermine the legitimacy of the court. Legitimacy does not require, sociological legitimacy does not require a grounding in mechanical jurisprudence. So to answer Dick's question directly, I find very little empirical support for the hypothesis that deviations from stare decisis undermine or even affect in any way the legitimacy of the court. But what does? If it's not stare decisis, does anything? What does? And so I think in thinking about that question, we need to take a step back and ask, what is it about stare decisis that might, in principle, contribute to legitimacy? And I think I have an answer to that. Stare decisis is a form of principled decision-making. Some legal scholars refer to this as reasoned elaboration in judicial opinions. The research shows that the American people expect and accept principled decision-making. On the other hand, they detest strategic decision-making. Strategic decision-making is what politicians do, and especially politicians in Congress. Moreover, and this point is very important, ideology is perceived as being principle. Strategic decision-making is not. So judges who engage in strategic decision-making or in-seer decision-making are nothing more than perceived as politicians in robes. And as Dick alluded in the beginning, the number one thing that undermines judicial legitimacy is the perception that judges are not different from ordinary politicians. So again, to answer one of Dick's questions, I think the court need not worry about abandoning stare decisis and its consequences for institutional decision-making. What the court needs to worry about is whether its motives are perceived as sincere or strategic. Now, very briefly, I have some empirical evidence on this score from a survey that's just been conducted of a nationally representative sample of the American people. This is what I call the new math of legitimacy. So I put to the American people the question of overturning Dobbs. What would they think about that? And so the new math allows me to calculate two quantities. First, the percentage of people who approve of overturning Dobbs, and that's a big number. But secondly, we need to always remember that legitimacy is for losers. And what that means is we have to look at people who will accept a decision with which they disagree. If you put those two quantities together in the new math, you will find that 90% of the American people would welcome the overturning of, that's not true. 90% of the American people would accept the overturning of Dobbs. Now, I don't want for Dobbs, or maybe y'all do, but maybe you don't. I don't think Dobbs necessarily needs to hijack this panel. So I'm going to shut up. I have more to say about Dobbs if anyone is interested in its connection to legitimacy, but I think I'll stop right here at the moment.
Okay, thank you very, very much, Jim. And so now, Tara Grove, we're covering a lot of ground here, but I hope you might take us a little bit in a different direction. The direction that we've been going so far has been involving perceptions of how the court actually decides cases and perceptions of the way the court decides cases. You're a scholar of the separation of powers and the judicial role in the separation of powers. I'm hoping you might take us a little bit more in a normative direction and to talk about what, if anything, attention to history and the separation of powers can teach us about how the court ought to decide cases, how large a role stare decisis ought to play in its decision making. And I guess just more generally, if you were advising the justices in the wake of Dobbs or otherwise, how they should think about stare decisis, how would that be?
Right. So I think I just want to piggyback on some of your comments at the very beginning, Dick, and also what Jim and Michael have said as well. Stare decisis can't be absolute. And I think everyone agrees on that. I think if we asked anyone listening to this, can you pick a list of decisions you'd love to see the Supreme Court reverse? They would have a list. And so for some people, it would include decisions from this past term, right? Some people would put Dobbs very high on that list of decisions to reverse. And I think that reflects something really important about the Supreme Court's role in our modern world. Because the Supreme Court's role is so consequential, overturning precedent is extraordinarily consequential, and not overturning precedent is also extraordinarily consequential. And I think that helps explain some of the history that Michael was telling us. It matters more now what the Supreme Court decides to do with a given case than it did in the 19th century for many people. And I think we already see some of that reflected in the Supreme Court stare decisis jurisprudence. There is, in fact, a doctrine on stare decisis. And some of that doctrine reflects the consequential nature of Supreme Court decisions. When the court says we care about whether the public has relied on a prior decision, it also reflects the Supreme Court's role vis-a-vis the lower courts. So some of what the Supreme Court considers, like whether we've actually created a legal test, a workable doctrine for lower courts, that matters. Whether this decision makes sense in light of all the other stuff we've said, that matters. And this is all the Supreme Court's role in guiding the lower courts. I think what's less clear in the Supreme Court's current doctrine, and gets to your normative question, is what else the Supreme Court should consider. Should the Supreme Court take into account what Jim was talking about, its sociological legitimacy? Now, it may be true that the public doesn't care about whether the Supreme Court overturns precedent in general, and I tend to agree with that. It's hard for me to imagine that the public would care about stare decisis itself as a concept. But the public cares deeply about some precedents. And should the court take that into account? This was a huge, huge fight between Planned Parenthood versus Casey and Dobbs. So in Planned Parenthood versus Casey, the per curiam opinion said we should take into account the likely public reaction to an overturning of Roe versus Wade, and that is a reason not to overturn it. Now, this, of course, is not explicitly a stare decisis factor. The Casey court set out 4 other factors and then talked about this issue, but didn't explicitly say this was a factor. And the Supreme Court has never recognized it as an actual factor, but it clearly mattered to the judges in that case. And I would submit has mattered to Supreme Court justices in many other cases. That's how some scholars explain the switch in time in 1937 when the Supreme Court changed course on the New Deal. That factor, that concern about the external reaction to opinions led the Supreme Court to slow walk many civil rights cases after Brown versus the Board of Education in a way that I think many of us find to be disgraceful. So in Dobbs, the court actually took this up. They didn't ignore it. They said, yeah, there might be a public reaction to this case. And not only are we not going to consider that, but we should not consider that. And I think that's the really difficult question for the Supreme Court. Whatever the public's actual reaction, should its decisions as a normative matter take into account what the public is likely to do? One argument for that perspective is that it would make the opinions more democratically legitimate. If you actually do care about democratic legitimacy, you'd say, well, the Supreme Court should look and see what does the public think we should do? And if the public cares deeply about this issue and seems to have a strong perspective, then we should take that into account. But there are a lot of reasons to be worried about that as well. How good a job is the Supreme Court going to do in figuring out public opinion? As Jim said, it's hard for political scientists. How are 9 justices whose backgrounds do not resemble most members of the public going to figure out what the public perceives an opinion to be? And will they be more drawn to elite opinions rather than general public opinion? Will they be drawn to elite opinions of a particular ideology, the people they kind of hang out with? Or will it be all elite opinions? So they might not be very good at it. And to take us back to the post-Brown era, the Supreme Court refused to enforce civil rights in a number of cases because it was worried about the public's reaction. And I'll identify just one, a case called Name versus Name in 1955. The Supreme Court was asked to consider the validity of Virginia's ban on interracial marriage. 1955, the year after Brown. And the court, for reasons that are truly unacceptable on legal grounds, said we're not going to rule in this case. And I want to be clear for those those out there who don't know this, the Supreme Court at that time did not have as broad discretionary certiorari jurisdiction. It actually had mandatory appellate jurisdiction over the case, but still dismissed the case twice. And to put it in perspective, 12 years later, the Supreme Court in Loving versus Virginia held that Virginia's ban on interracial marriage was invalid. Now, to us today, particularly the students out there, the difference between 1955 and 1967 might not seem like such a big deal. But just imagine if the Supreme Court had done the same thing with respect to same-sex marriage. Same-sex couples were granted a right to same-sex marriage in 2015. They would still be waiting until the year 2027. So I think there are really, really reasons to be concerned about the Supreme Court taking into account its perception of how the public perceives it. And I'll stop there.
Okay, thank you very much, Tara. That was terrific. And so now, Darren Hutchinson, again, a different dimension of the topic. I hope you might help us and help the audience think a little bit about what's likely to come next following what the Supreme Court has done recently, and especially what the Supreme Court did in Dobbs. In a concurring opinion, Justice Thomas specifically signaled that he thought a number of the Supreme Court's substantive due process decisions ought to be the next to go. Mike Greben has called attention to the affirmative action case pending before the court. Would you be willing to go out on a little bit of a limb for us and make some predictions for us, maybe with a bit of specific reference to how much influence, if anything, you think stare decisis will have on the way that the court thinks about these high-profile decisions clearly on its docket?
Thank you so much, and I'll be happy to do that. Before I go into my answer specifically about some of the sexuality cases, I do want to point out something that we haven't said yet, but the court can overrule without overruling, or at least the court can drastically limit precedent without overturning. And that might be a safer place for the court if it's concerned about legitimacy or at least public outcry over certain decisions. And I think Casey's somewhat of an example of that. At least many scholars have pointed to it. The court upheld what it called the essential holding of Roe, but at the same time, it upheld a lot of statutes that strictly applying the Roe doctrine would not have been upheld. So we talk about we talk about Brown still being valid precedent, but in many ways, subsequent doctrines like the intent rule have undermined a lot of the work that Brown could have done. Now, I want to go specifically to cases involving same-sex marriage. That would be Obergefell, sexual privacy, which was Lawrence versus Texas, and also contraceptive cases, and the landmark case on that would be Griswold. There's been a lot of debate following Dobbs about what the court might do if it were presented a challenge to some of those rights in the future. Some folks have argued that some of these rights are so important, such as the right in Griswold, that they couldn't imagine the court striking it down. I take a different perspective on it, and it comes from two places. One, and I'm going to go more into the Dobbs decision than most of the people who spoke before me have. One is just the case itself. I mean, there's so many ways in which this case implicates those decisions that it would almost be a reversal if the court didn't invalidate Obergefell and other rights, because it's so strongly implicated that those cases were poorly decided. And I say that for a couple of reasons. So the audience is filled primarily with law students. You know the story about fundamental rights is they're decided and found under the court's substantive due process doctrine. In order to do that, there's this tradition-based analysis. Sometimes it's strictly backwards looking. Sometimes it's a mixture of looking to the past and looking to the forward, and also looking to foreign countries. The cases, the abortion cases, Roe, Casey, and also the sexual orientation and sexual privacy cases all apply this evolutionary style of substantive due process. They look to the past, but they're also not wedded to the past. And that evolutionary thinking of substantive due process was articulated most elaborately in Poe versus Ullman by Justice Harlan. And what Justice Harlan said is that tradition is a living thing, so it's not fixed in time. And also that rights that the court deems to be fundamental are not, they're on a continuum rather than being isolated points out in time. All right, that doctrine is gone if you look at Dobbs. So it was a very, very blatant, very intentional rejection of that evolutionary style of analysis. It just so happens that Obergefell and Lawrence were built on that evolutionary style of thinking about tradition. And with that being gone, and also the precedent that was the building block for the same-sex marriage cases being gone, and that I point to Casey more so than anything else. With that being gone, it's really hard to imagine the court not reversing Obergefell, Lawrence versus Sexes, and potentially Griswold. Another reason for my concern, and this is going to be a little different than what my colleagues in constitutional law have said, is that even with the case that the court says is controlling in an argument about substantive due process, and that was Glucksberg, even that case, the court didn't technically follow that if you look at it. And I say this for a number of reasons. First, Glucksberg talks about this deeply rooted analysis, which suggests that you have to go backwards in time to figure out if a right is fundamental or not. If you really look through the case, however, and also subsequent cases in interpreting it doesn't compel the outcome that we saw in Dobbs. Why? Dobbs, Glucksberg, for all of the criticism it's received, actually does what we expect in a due process case. It looks to see whether advancements have been made so that we can find a new type of tradition. All right. It also looks to what foreign courts have done and foreign governments with respect to assisted suicide, and finds that those traditions had not become solid enough such that the court should recognize a tradition of assisting suicide. And Dobbs, however, that time, and if the court itself, with the precedent that it promotes as being controlling, kind of evades a lot of the outcomes there, I cannot imagine cases where a majority of the court is currently constituted actually disagrees with the outcome, why they would apply stare decisis and uphold and affirm those cases despite their disagreement. Just a little bit on Griswold. Griswold, I think, is a different matter. The stakes of saying that there's no right to contraceptive use completely, I think, would be differently received because of the magnitude of the people that would be affected than, say, same-sex marriage. However, since the court is now questioning evolutionary substantive due process, I can see a distinction being made between Griswold on the one hand and Eisenstadt and Carey on the other hand. So even if married couples have access to contraception, what would this mean for minors? And what would this mean for people who are unmarried? So there are a lot of questions that remain. And just a final note, because gays and lesbians or LGBT people are a smaller percentage of the population, I think it would be easier for the court to overturn those cases that are very important in terms of humanizing that population than it would be to overturn a broader set of protections and liberty interests. And then another piece of it is that the tradition of recognizing LGBT rights is much shorter than the tradition on abortion and contraception. So I just find it difficult to imagine them affirming the Obergefell ruling today, given the content of the decision and also the political stakes. The question would be, how does it get to the court? How do you get a case like that back to the court? And I think there are probably a lot of states willing to go on the record banning same-sex marriage to get that case back to the court.
Thank you very much, Darren, very illuminating. And so now, Kimberly, I guess in some ways back to the big empirical questions. You're a professional court watcher. It's your job to be paying attention to these 9 justices, trying to figure out what they're thinking, what they're likely to do. Is you write about cases coming before the Supreme Court? In what of the various senses in which stare decisis might matter? Because people care about it, because it somehow is a part of our constitutional tradition, because it's fundamental to the rule of law. Do you think that the justices care about this? Do you think some of them care more about it than others? Where do you think the court is likely to go? And that's a big omnibus question, but I assume these are all things that you're thinking about all the time.
Well, they are. Before I get started answering your question, I wanted to apologize for my bomb shelter set up today. In the process of carrying out my duties as a professional court watcher, I was listening to arguments this morning, and the justices declined to follow their long-standing modern precedent of caring about time limits and arguments. So here, this is what we've got. But I will say that question, it's a big question, but it's one I feel like we're living right in the middle of right now. We've all talked about, the Dobbs decision. Michael mentioned the affirmative action cases that are coming up. But it seems to me that looking at the cases that are just coming to the court, it seems to me that there are more and more where the ask is explicitly to overturn precedent, not to limit it in some of the ways that, others have suggested, but to really overturn it. And so, when we're in that moment, it is important to look at all the justices. And I think most of them, except with one big exception, do care about precedent. So getting the big exception out of the way, Justice Thomas has repeatedly said that he's willing to decide issues anew. And if precedent is wrong, that the court should change it. But with the other justices, I think they all care about precedent to some extent, but it just really manifests itself in different ways. And I'm sorry to keep talking about Dobbs, but I think it was one of the starkest examples for me of this. So we have Justices Sotomayor and Justice Brett Kavanaugh, who are kind of on the opposite ends of the ideological spectrum. And if we look at arguments going way back into December of 2021 in there, precedent was on top of both of their minds. So, but just in very different ways. So we saw Justice Sotomayor ask a very memorable line: how will the Supreme Court get the stench off of it if people think that the rule of law and the laws that govern us change with the composition of the court? But then you look to Justice Kavanaugh, and I think he had precedent in mind when he was talking about kind of the special justifications for overturning a case. And when you get it so wrong, according to him, you have to fix it. Otherwise, the legitimacy of the court is really in question. And so, I think as we look at this summer, I can't quite remember a time when the justices were in the headlines so much over their summer break as they were this term. But a lot of that fallout seems to suggest that the public sees precedent more in line with the way Justice Sotomayor was thinking about it. We've seen historic lows of the court's legitimacy and its approval rating. And I think that's really the only reason that you care about stare decisis, right? There's no reason to follow a case that you think is wrong unless it is for the legitimacy of the court. And so, that's caused a lot of the justices to speak in their public comments about legitimacy, about stare decisis. And we saw Justice Kagan a number of times describe the importance of precedent and following precedents to the court's legitimacy, and say when the court does not act like a court, when it goes out of its way to overturn precedent, to decide more than it needs to, then it's really calling its own legitimacy into play. So I think that most of the justices do really care about precedent and what it means for their legitimacy. But I just think it shows up in so many different ways. And I think Dobbs is a good example of that.
So this has been an extremely informative set of presentations, and I thank you for opening up so many areas of the topic. We have relatively little time before we ought to go to the group, to the opportunity for the audience to ask questions. But with so much on the table, I would just ask a very open-ended question of all of you. Having heard each other, is there any point that you would now like to make before we go on to the audience questions? It's hard for me to believe that there wouldn't be, and so please don't hold back.
So I just wanted to note one disconnect between Jim Gibson's findings and Justice Kagan's recent comments. Justice Kagan's comments really reflected an assumption that the public cares about the Supreme Court's reversal of precedent in general. Jim's findings suggest that they don't. And I think that underscores that really what the public cares about are the decisions themselves. And what people are upset about with respect to Dobbs is not that it overturned precedent, but that it made a decision that many people find to be unacceptable. I'll also say in some of the opinion polls that I've seen, and I'm curious if Jim has seen this, if you've seen this, Kimberly, there seems to be a huge difference between the way that conservatives view the Dobbs decisions and the way that progressives view the Dobbs decision. And I think that's an important aspect of the public's reaction as well, that we have two different publics, at least in our society, and they have a very different perspective on where the Supreme Court is going.
So I think that all of that is correct, but the stare decisis issue doesn't exist in a vacuum. It's coming on the heels of fairly controversial confirmation decisions, blocking Merrick Garland, followed by the Trump appointees. Other aspects of what the court is doing triggered the Biden Commission, examining whether the structure of the Supreme Court and its role should be altered. And then, of course, the leak last term of the draft Dobbs opinion, which probably mattered a whole lot more to the court and court watchers like us than the general public. But I think that it did reflect, in combination with everything else, a sense that the court was verging on being a political body, as opposed to an exponent of the rule of law that was attempting to instill stability and adherence to sound principles that transcend the members of the court. And this is what the court said in Vasquez versus Hillary, when it was extolling the virtues of stare decisis, that it's important that the public believe that decisions are made because they're grounded in the law rather than in the proclivities of individuals. And the combination of all of those things, the vitriolic confirmation hearings, the politicization of it, the kind of fragmentation of our world in social media, in political opinions, in the breakdowns over whether the election was legitimate in January 6th and the perceptions about it, Charlottesville. I don't think any of those things can be completely divorced from how the Supreme Court is perceived. And stare decisis is a piece of the puzzle. It's something that they talk about. It's something that we talk about because stability in the rule of law sounds like law, as opposed to just what new individuals on the court want to do with it. But I think what we're really witnessing is the court being kind of caught in a tsunami of polarization that is sweeping across all of our institutions.
Yeah, Jim, what do you think? Can the court escape that tsunami in the time of two publics, as Tara described it?
So we ought to review the bidding just a little bit, though, and I'll answer that question, Dick. So everything changed in about 2020. Before 2020, the court was able to get away with murder without affecting its legitimacy. You can go beginning with Bush versus Gore, but you can look at Obamacare, you can look at all kinds of decisions, and the court was able to decide against the preferences of the majority with impunity. Now, there are two papers that I commend to everyone in the audience. The first is a paper by Stephen Jesse, one of Tara's colleagues in the political science department at UT, and Maya Sen, who's one of your colleagues at Harvard, Dick. And what they show is that the court dramatically shifted to the right beginning in 2020. So what I think the Dobbs decision did is it was the camel that broke the straw that broke the camel's back. And had that decision been made in 2019, I don't think the consequences would have been nearly as great. Kimberly, the court's legitimacy has not dipped until very recently. What you're referring to is approval, and that's a very different issue. And so the second paper, and then I'll shut up. The second paper is my paper at SSRN that shows the impact of Dobbs. But those two papers show that 2020 changed everything and that Dobbs changed everything.
I just want a brief thing. I know we're about to move on, but I guess one thing for the audience and for the rest of us to think about is what happens if a majority of the public deems the Supreme Court or federal courts generally not to be legitimate? Does that mean something happens in terms of voting? Does that mean their rulings are ignored? And what's the import of that? Does it mean that there's going to be more attempts to regulate the court by Congress? The Biden commission didn't really do anything. I mean, that was pre-Dobbs. But still, there hasn't been new proposals about going after the justices. So I guess one question for us to contemplate is that where will we see some type of response? How will it play out in concrete ways if the public views the court as not being legitimate? I can't imagine it means that the court shifts into some kind of more liberal stance, given how ideological it is at the moment. But legitimacy as an abstract concept has to give way to something more meaningful in terms of how the public treats it and how the other branches of government do as well.
Okay, so thank you. I think this has been really an extraordinary discussion. I'm sorry that we've run so long as we have, so we're not going to have very much time to deal with audience questions because we've got a hard stop of 1:30. But I'm going to pop out the questions in the order that they were asked, and we'll hope that one of you might step forward to try to deal with them. I said I'd do the order they were asked. I think I'll skip to the second because it's more directly on point of what we've been talking about. And here was the question: how can Loving against Virginia, which upheld a right to interracial marriage, be distinguished from the other sex-related substantive due process cases, if at all? Any of you?
I mean, that I'll defer really to Darren on this, but that case can be viewed as an equal protection case and therefore grounded in the explicit text of the 14th Amendment, and as a result, distinguished on that basis and preserved. And I think more generally, the question of whether the other major substantive due process holdings will be overruled, ranging from Griswold all the way to Obergefell, they may implicate different considerations for different justices. Some justices do care a lot about how the court is perceived. And it's not just a question of whether the decision is wrong. And if they don't want to overrule a decision like Obergefell, they have two routes. One, they can deny certiorari. They don't have to take a case, so discretion can allow them to avoid the issue for a long time if they want to. And the second is they can weigh in their toolkit of stare decisis factors, workability, reliance interests. You'd be breaking apart families potentially. They could conclude, if they wanted to, that we're not going to touch those. And when you look across the range of the justices, I think that this was touched on earlier. They all have slightly different theories of stare decisis, ranging from, at one end, Thomas, it's basically the last desperate argument, to Justice Kagan, who takes it very seriously. But because of that diversity of interests, I don't think you can extrapolate from Dobbs exactly what they will do in future cases.
Right.
I'll slightly disagree because if you look beyond Dobbs and see who dissented Anna Bergefell in some of those other cases and the arguments that were utilized, it's really hard to then come back and say that you're going to affirm those cases that you've expressed such strong disagreement with. It may happen, but they've already had to grapple with the interest of, say, breaking up families, et cetera, and Obergefell itself, and Thomas, Alito, Roberts, that didn't matter to them. They said that the case was not based on U.S. constitutional law, but something else, the judge's personal preferences. So I'm a little more concerned and worried.
Mhm. So if I could fold one of the questions that was asked into a slightly broader question that picks up on something that Mike Dreeben just said. It's one thing how the justices will rule when they actually have a case before them. Some of the justices who are more concerned about legitimacy, I expect, would be eager to keep these cases off the court's docket by finding ways to avoid them. Foremost among those, I would guess, Chief Justice Roberts, who also seems to care the most about stare decisis. What do you think about Roberts' prospect for success in keeping things off the docket?
And that's a tough one. So the interest in keeping them off the docket are similar to the interest in not overturning, especially in a case like Dobbs. But I mean, I was stunned that Roberts, not stunned, I was a little surprised, I should say, that Roberts was the only one of the conservatives to say, you know, let's stay with Roe. We can, Roe and Casey, we can uphold the statute doing that. All right. So not only did they grant cert, but they also then went ahead and overturned it. So there was no place in the chain of progression where they said, let's do something that's less dramatic. And because the right was abortion and it's been around for a much longer time period, and the implications are great in terms of women's bodies, healthcare, economic well-being, et cetera. It's the stakes may not be as grand in other settings. So if they did it here, I just find it hard for them not to do it in other cases. And for a while, it may be evasion, but ultimately, I think if it ever gets there, it'll be overturning.
Right. So I thank you all so very, very much. We do have a hard stop time of 1:30 because of the law school schedule, but I think this has just been an extraordinary set of ruminations that you have all given us. And on behalf of the Harvard Law School community, I thank you so much for being so generous with your time and thought, members of the panel. And with that, thank you all.